Good morning. Today's Monday, June 16th. Welcome to the First District Court of Appeals. I hope everyone had a great weekend, and those of you who are fathers, I hope you had a great Father's Day, and for the rest of you, I hope you celebrated the fathers in your lives. Today we have 4 cases that are on the docket. Only 3 will be arguing this morning. I'm going to be calling the cases. For those that are arguing, if you can please identify yourselves and your readiness to proceed. So the first case that I have is case number C240534, State of Ohio versus Williams, and this is scheduled for argument.
Scott Heaton on behalf of the state, I'm here for Ms. Lott this morning.
Thank you for being here. The next case we have is case number C240294, Chris Clark et al. Versus Dr. Durrani et al. If parties can please identify themselves and readiness to proceed.
Bill Williamson on behalf of Dr. Durrani, ready to proceed, Your Honor.
Ben Moran on behalf of the appellee, Chris Clark, unless Mr. Stafford Mason contacted me and said he wasn't sure he was going to get here in time, so I told him I would fill it.
Okay, well, thank you for being here. The next case we have has submitted on the briefs, will not be arguing this morning. Case number C240699, Marianne Bush Harsh et al. Versus NHC 5 Points LLC et al. And the last case we have, which is scheduled to argue, is cases number C230599, C240596, 435 Elm Investments LLC versus CBD Investments Limited et al. If parties can please identify themselves.
Bill Williamson on behalf of the 35 L, ready to proceed, Your Honor.
Okay?
William Becker on behalf of Ronald Bullshit, we're ready to proceed.
Okay, all right. All right, so we'll begin with State of Ohio versus Williams.
If it pleases the court.
Good morning, how are you doing?
Fine, thank you. I'd like to reserve
Good to
3
see you.
minutes.
How much time would you like to
3
reserve?
minutes.
2 minutes?
3.
3 minutes, all right, you can start whenever you're ready.
This case is no doubt, factually, is a terrible situation. And I was a young man who did suffer from a degree of schizophrenia, made a call to police saying that he had been assaulted at one of the local parks. And he said that he was now at home. Police came to the house to talk to him. The police officer that showed up, my client immediately attacked the officer and caused some severe injuries. He was ultimately indicted on 4 various counts: 1, an attempted murder, felonious assault of a police officer with serious injuries, making a false police report, and so on. He ultimately initially was found to be incompetent to stand trial, went to Summit, upon medication was restored to competency, and ultimately entered a plea. The problem with the plea that was entered, it was the attempt, I think, that he believed that he was eligible for community control, and indicated by the plea agreement that he signed was blank when it said, is there any mandatory time? During the court going over his rights.
Because I understand one of the issues is that it did have a mandatory sentence, and that was also not articulated.
Yeah, with a felonious assault on a police officer, the felony of the 2nd degree is mandatory imprisonment. The court started out by explaining to the young man what the potential penalties could be for a 1st degree or a 2nd degree felony, and for the 3rd degree felony or the 2nd degree felony that he was also charged with. I think the felonious assault on a police officer, I think, was an F1, and it was 2 to 11, something like that. And he went on and gave an explanation of what, being in prison and what the maximum penalties could be, indicated what the Reagan edition could be set with it, and then mildly mentioned that although it's not applicable here, he went along and did a detailed description of what community control or
Can I
probation
ask you, I'm
consists
going to
of.
ask you a question about that. So just before he said, it's not really applicable here. He said, we are going to talk about prison. We are going to talk about community control. It's not really applicable here. By saying that, is that a partial compliance?
I don't think it is. The compliance of the rule says that you got to tell them that it's mandatory, that you got mandatory imprisonment. And what makes it more difficult is that while he goes into the explanations and he gets to a certain point, the young man looks to the court and says, my lawyer told me that I should ask the court for probation. And he says, we'll get back to that later. And then he goes on and does this detailed description of community control, and then goes on and, and talks about the fines and the maximum penalties, and he always uses it, potentially could receive not, this many years, up to this many years. And, to show it, how it worked that way, is then he goes on and he says yes to everything. He was a little bit confused when the court talked about the maximum fine of $20,000. But the topper of it all is, and I know that the state said it in their brief, that, well, if you take the totality of the circumstances, he certainly understood it. But what's interesting is the very last comment in mitigation at sentencing, when the lawyer talks after the young man talked, that Mr. Williams made a statement to the court and to the family, and his grandmother and his mother spoke, and even his grandmother had indicated, I hope the court would seem fit to let him come back to the, be with the community and so on. But then the lawyer says at the end, and the very last thing on his behalf, I humbly pray on his behalf for a period of community control. I know that's a huge ask, community control with strict supervision with the MDO unit, and I'll ask the court to give him an opportunity to express his concerns to the court.
So you're basically arguing that under the totality of the circumstances, that it couldn't be substantial compliance because it was not in fact understood.
Right. He did not, it's clear he didn't understand it. He didn't understand it during, at the plea hearing, when he said the question about, my lawyer told me to ask the court for probation. It was not voluntary. I mean, I know the situation is terrible and that he had gotten some things in return, but the boy ended up getting the maximum penalty under the under the felonious assault.
Attorney Serkin, is there something you're hoping that would be different if we were to find it to be complete non-compliance? Of course, then there would be no prejudice and it would be remanded for resentencing.
I think not to be remanded for resentencing, but to vacate the plea.
I mean, remanded
Yeah.
for, yes, that's correct.
I still think that under the circumstances, and I know that the psychological makeups that were made on this situation, he did not know what he was doing at the time that the offense occurred. Following it, and he started to come out of the episode that I believe that he was under when this event happened, he realized that what he had done, and he was apologetic. And because he apologized in the police cruiser going downtown, they felt that he was not met the standard of not guilty by reason of insanity.
Now, should that influence our decision at all here?
Pardon?
Should that, it sounds like you're making a merits argument. Should that influence our decision here?
I think it should. I think that there's a valid reason for it to go back, because I don't think, unfortunately, he had a change of lawyers at the very last minute. He was initially represented by, I think, Richard Field, who I think was very compassionate with him and tried to get examinations. At the very last, at the tail end of this case, Mr. Field took a position as a full-time public defender in Claremont County, and he had to withdraw from the case, and Mr. Rubenstein was appointed. And I know that he's a very competent lawyer, but I think he overlooked the fact that if you read the statute closely, it goes on to say that in the case of a peace officer, under the laws of Ohio, it becomes a mandatory prison time. And I don't think that this boy was ever told or understood that by his plea, he had a mandatory prison sentence.
Counsel, are you arguing ineffective assistance at this point?
I think you can, but I don't think it's necessary for me to do that here, to label and to raise a question that it was ineffective, because it would have gone outside the record, what the discussions were between Mr. Rubenstein in him, and that would be for post-conviction. But I don't think that we have to wait for post-conviction. I think the law is clear that if the court does not follow the rule of 11C2A that says that you must be told the maximum, if imprisonment, it's mandatory, and prejudice is presumed. And I know the totality of the circumstances comes into play, and then subjectively. And I think looking at it subjectively, this boy did not realize at the time he pled, nor at the day of sentencing, that he faced a mandatory prison sentence. And under that circumstances, his plea is not voluntary, and the court should not have accepted the plea.
And do you introduce any evidence of prejudice, assuming that the court did not completely fail to comply with C2A?
I think the court completely failed to comply.
Well,
with
but
it.
assuming the court did not, is there any evidence of prejudice?
Well, I don't think prejudice is, I don't have to prove it.
If it was a complete failure? My question
Yeah,
is if there was not a complete,
the
I'm sorry,
answer is,
counsel.
I think no.
Counsel?
I think the law is pretty clear on the fact that there's a complete failure. I mean, I can't conceive that the fact of saying that although it's not applicable here, when all the talk by the court is that potentially you could receive, potentially, always put it into that kind of a frame, never that I must incarcerate you. He even at this, and again at the sentencing, the comments by the grandmother, I now understand, look, it was a serious felony. There was a possibility that there'd be incarceration, but there was tremendous mitigation here. I mean, this young man suffered from the psychological, the schizophrenia from the time he was an adolescent, starting back when he was before the juvenile court.
Counsel, can I take a run at my question one more time? Assuming that there wasn't a complete failure, do you present any evidence of prejudice?
Yes, I think that he should, the prejudice would have been that he would not have pled guilty, and he could, that, his risk was only, it reduced what his possible risk would have been if he'd gone to trial. And I tried, as I say, I think that going back on this case, I think that there's psychologists that could have been found that could have testified and raised enough of an issue to raise a valid not guilty by reason of insanity defense. And I think he was entitled to have that. And I don't think that we have to wait to go through post-conviction to do that.
But that's all outside the record at this point.
Pardon, and that's off the record. It would have been discussions with Mr. Rubenstein. But I mean, it's clear in there that taking the totality of circumstances, and again, the law seems to me that if there's a failure under C2A, that it's a mandatory, and it's mandatory to the court that there's prejudice, and that it should be vacated and remanded back and start zero again with it. There are no further questions. I'll leave it with the state.
I'll reserve the remainder of your time. Thank you. Good morning.
Good morning, how are you?
Good, how are you?
Good, thank you. As Judge Moore started to allude to, this is, the test here is substantial compliance, whether or not the trial court substantially complied with Criminal Rule 11. And when you look
And
at
why is that?
Why is that? Because that's just what the law says, that when you're saying that Criminal Rule 11 was not followed, you look to see if there was substantial compliance and whether the totality of the circumstances shows whether or not the defendant
Right, but
understood.
why is there substantial compliance here as opposed to total noncompliance? And obviously, the difference is prejudice, and, that's a major difference.
That is a difference. I'm just relying on Nero mainly, which says that that's a test that you apply. And when you look at the things that were said here, you can see that there might have been this.
So you're saying that you always apply substantial compliance, and noncompliance can never apply?
I'm sorry?
Are you saying that total noncompliance can never be applicable?
I don't
That
think.
the sole test is substantial compliance?
If the trial court did not address part of Criminal Rule 11 at all, that would change things, obviously. But that's not what happened here. When you look at the plea hearing, when you read through it, you see that the trial court explained everything it needed to explain to Mr. Williams. And all the comments that everyone made shows that everyone knew that this wasn't going to be probation, that he was going to go to prison for this for some period of time.
Mr. Heenan, can you please respond to opposing counsel's statement that the trial court never at any point said that prison was mandatory.
I think when the judge said, that community control is not really applicable here.
Well, I'm going to push back a little bit on that.
Sure.
So what the trial court said, let me find it in my notes. It started that with, we are going to talk about prison, we are going to talk about community control. It's not really applicable here. So taking that, could the defendant have not understood that what the judge was saying when he said it's not really applicable here? Could he have thought he was talking about prison? Since
I
it was
see
in
it-
the same,
I see that as, yes, he's being told, we're going to talk about it, it's not going to apply here, you're going to be going to prison. Now, could he said it in more words like I just did? Sure, he could have. But again, now we're starting to get into things where we're looking outside the scope of the record on appeal, and we're looking at stuff that might be appropriate for post-conviction petitions.
I don't think you understand what I'm saying here. Okay, what he said is, we are going to talk about prison, we are going to talk about community control. Those two statements. And then he says it's not really applicable here. I mean, could that be read as that was part of the preceding two sentences in that paragraph?
The way I've read this record is that the judge wanted to make sure he explained everything to him and told him that, we're going to talk about this, but it's not going to happen.
Okay, so that's with community control.
Yes.
And that's one of the things that the trial court has to discuss, is that somebody is ineligible for community control. Does the trial court also have to say that prison time is mandatory? Because it's not, it's, if prison time isn't mandatory, sure, he'd be eligible for community control, but is the trial court required to say both, that he's not eligible for community control and he is going to have a mandatory term?
I wish I had a better answer for you, but I found out last night that I was getting this case. I was having dinner,
Okay.
so I don't.
If it
have
helps,
an
I couldn't
exact-
find anything
I-
on
I
it,
would say
so
I
I was
don't-
hoping that you might
I was
help.
going through my memory and trying to think, and I don't know offhand. Again, my feeling on this is that when you look at the totality of the circumstances, is there, based off the stuff that Mr. Serkins talked about today, potentially a good petition for post-conviction? Maybe. I don't know. I don't know what was going on inside Mr. Williams' head when he did this.
Isn't that on the plea form,
Is what on the plea form?
that it's going to be mandatory?
There is a spot on the plea form up on the top in the little grid where you can put down mandatory time. But usually that's when you would put down that, like on an MDO spec, where it's like, you're getting 10 years, we're writing to 10 here, is the way I've always seen that used.
But that was left blank in this case,
That
right?
was left blank in this case. But again, I think this again goes to, these arguments are better suited for a post-conviction petition, especially when you start talking about, well, would the plea have been made otherwise? I mean, there's nothing in the brief about that. There's nothing that shows that he wouldn't. And all the things he's talking about now, about, well, maybe we could have found more evidence of an NGRI plea or some other mitigation. Again, maybe those are good things for a post-conviction petition, but they're not good for a direct appeal when those aren't in the record.
So was it trial, I'm sorry.
I was going to say they are good for a direct appeal if there's no prejudice requirement to be established.
Well, if there's no prejudice required, you don't even have to get there, because you say,
Correct.
this box was not checked,
Correct.
and that's all we
Yeah,
do.
none of that comes in, none of that is applicable, none of that is germane, and we are in direct appeal, so, and that's really what this case is about, whether we have substantial compliance or total noncompliance. And what I understood you to say is if the bench engages in the colloquy, that automatically puts you into substantial compliance. What I hear the appellant saying is that the portion of the colloquy on mandatory sentencing, that alone must be evaluated on substantial compliance versus total noncompliance.
That is his argument.
Is that what your understanding, the
That is my
difference is?
understanding of the arguments today, yes.
Thank you.
Unless the court has any
I
questions.
think that Judge Moore may.
No,
have a
Oh,
question.
I'm sorry, that's right.
I'm fine, thank you.
You're good? Okay. Great. Thank you so much. We ask that you affirm.
Thank you.
I think the cases indicate that if there is substantial compliance and in looking at the totality of it, subjectively, you could tell to make a subjective determination that the individual defendant understood it. I think it's clear here that subjectively, he didn't understand it. And that's why he made the comment that he made to the court, my lawyer told me to ask for probation. And the court just slaps that off. It's clear at that point.
So are you saying for total noncompliance that there's an objective and a subjective inquiry?
Well, the courts say that if you can tell by the totality of circumstances, you can make a subjective determination, that would overcome the presumption. And in this circumstances, I don't think that that's even, first of all, I don't think that's applicable. It's just like if he fails to give the constitutional rule, is it supposed to be explained to the defendant? It's virtually, from what I can tell from the cases, that it's an involuntary plea. And I think the same thing here, where the court does not indicate that prison is mandatory and that the individual understands that. The court even went over and said, you signed this agreement, did you understand it, did you talk about it with your lawyers? And for what reason? Look, I've been in practice a heck of a long time, and I know when you fill those forms out, there's a reason that phrase is in there about the imprisonment, whether it's mandatory or not, that you always put in, you answer that question.
But, counsel, the trial court explained to the defendant that community control was not applicable here.
But he says it very early on, he says it's not applicable, but he puts it together with, why would he even go into community control?
Regardless, I don't know why, because it's, the only thing I saw in the record was that the trial court told the defendant expressly that community control was not applicable.
Okay. And then the young man...
Is there any evidence that the defendant did not understand those words, that community control was not applicable here?
Absolutely. He asked the court, my lawyer told me to ask for community control. Why would he ask for it if he's been told and he understands that I can't get probation? I mean, it's a clear indication of that. And it's clear, and his lawyer even said it. I mean, it shows it at the sentencing, that apparently the lawyer didn't look at the whole statute on the sentencing, where it says that in a case where there's a police officer or a peace officer of Ohio that suffers serious injury, that imprisonment is mandatory. You can't, even though there was a presumption against imprisonment on a first and second degree felony, but again, is an indication he did not understand it. And if he doesn't understand it, the plea is not voluntary. I mean, it's not whether he got a good deal, a bad deal, or whatever else. He did not understand. And it was not, and it's clear in the record here, that it was not a completely voluntary plea. And the court overlooked that, and for whatever reason, that remained blank on the plea form.
Mr. Cirkin, I'm going to ask you the same thing that I asked Mr. Heenan. Does the trial court have to both say that the defendant is not eligible for community control and that the sentence is mandatory, that a prison term is mandatory?
I think he has to say that.
Okay, do you have any case law?
I think that the cases that, that I cited, and I believe that there's been a couple cases that recently came out from various court of appeals. Very recently, there's a May 1st opinion in State of Ohio versus Smith out of the 8th Appellate District. It was decided on May 1st. It's 2025 Ohio 1548, where there's a discussion about it. And there's another one on May the 28th out of the Court of Appeals of the 9th Judicial District. Is 2025 Ohio 1909. And interestingly enough, that case's last name is Williams as well. Seemed to indicate that determining that the defendant is making a plea voluntarily, understanding the nature of the charges and the maximum penalty involved, and if applicable, that the defendant is not eligible for probation or for imposition of community sanctions at a sentencing hearing. And I would say that, just simply saying that, you're not eligible or it's not applicable here does not again, when you follow what's later said by the young man to the court, and if the court doesn't address that question when it's brought up, he never gets back to talking about his eligibility or non-eligibility for community control when that question was asked. And I think that taking it as the case law says, substantial compliance, I don't think that there was substantial compliance here.
Thank you, Attorney Serkin. Let me just see if there's any other questions from panel.
Thank
All
you.
right, thank you. Thank you both for your arguments this morning. We'll take the matter under submission, issue you a timely decision, and we wish you both a wonderful afternoon. Clark versus Durrani, please.
Apologies, Your Honor, I prefer not to have my voice crack while I am,
If you want, you can bring the glass up with you. Probably want to refill it there. All right.
Your Honors, may it please
Good
the court.
morning.
I would like to reserve 3 minutes for rebuttal.
Okay.
Phil Williamson on behalf of appellants. The facts in these Durrani-related cases matter, as this court has stated numerous times, and I think there are three to keep in mind as we go through argument here today. The first is the sort of background of Mr. Clark's injury, being rear-ended by a semi-truck when he was 19 years old, spending 20 years lifting furniture as a carpet cleaner, which Mr. Clark himself testified was absolutely back-breaking work. It caused his back to go out multiple times a year. He missed somewhere between 4 and 8 weeks of work prior to seeing Dr. Durrani. This is sort of the problems that brought him to Dr. Durrani. The second key fact, I think, is the 2011 MRI, which again is about a year before he sees Dr. Durrani for the first time, which reveals a host of back problems up and down his lumbar spine. Bulging discs, protrusions, hernias, and that steroid injections and pain medication are not addressing this problem, all, again, before Dr. Durrani ever sets eyes on this patient. The third, I think, important fact here is that after performing surgery in 2012, Dr. Durrani prescribed physical therapy for Mr. Clark. He did not go to physical therapy, but returned to that carpet cleaning job that had caused many of his back problems in the first place. And so by the time we come to trial, I think the first error for the court to consider is the failure to give a comparative negligence instruction here.
Well, let me ask you a question on that. So if I'm remembering the right Durrani case, the theory of the plaintiff's case was that this was an unnecessary surgery. Is that correct?
Yes, Your Honor, that is part of the, maybe the main part of plaintiff's argument.
Okay, so help me understand. If this was a surgery that never should have happened in the first place, how would physical therapy help?
So, Your Honor, it is, first of all, I think you will find that the record testimony tells you that post-surgery, at least some of Mr. Clark's back problems, some of Mr. Clark's physical ailments have improved. So, for example, 10 months post-surgery, his leg pain is gone. So, yes, while there is a fight about whether the surgery was necessary.
Well, I mean,
it's
that's what
also
the
clear
jury
that-
determined.
It's also clear that the surgery helped him.
Okay, but, all right, so the jury determined that this was an unnecessary surgery, correct?
Right, Your Honor. So here's one so physical therapy would have helped in the following respect. The bulk of the damages in this case are for pain and suffering. And those damages are at the very least exacerbated by the fact that Mr. Clark does not only fails to aid in his own recovery, but actually actively undermines it. We think certainly the pain and suffering damages in this case would have been significantly lower if Mr. Clark had actually participated in physical therapy. I will pull a page from opposing counsel's book and point out there are a number of Durrani-related cases where even though the jury finds that surgery is unnecessary and awards, for example, past medical damages, frequently the future medical damages awards, the pain and suffering awards, are actually pretty low because it turns out the unnecessary surgery didn't cause much in the way of injury to the plaintiffs. And I think you would at least have that.
But we can't
here.
look at those cases. We can
Well, you
only.
decided some of them, Your Honor,
I
but
mean,
fair.
Yeah.
But my point is, when the bulk of the damages are pain and suffering, and a plaintiff like actively exacerbates their own pain and suffering, we at least get to put that in front of the jury and say, all right, how much of this is the result of an unnecessary surgery, and how much of it is the fact that this plaintiff kept doing the thing that hurt them in the first place?
Thank you.
I realize you may not love that, Your Honor, but that is where we are, at least on the comparative
I appreciate
negligence
your answer.
instruction. I think the second core problem in this case is the instruction that was given, which is the absent defendant or the flight or the negative inference instruction, where the judge told the jury, you can draw a negative inference from the fact that Dr. Durrani is not here. A lot of this is not in dispute. This court has condemned as incorrect the instruction given in this case. The only fight is over whether that instruction was prejudicial. And it's difficult to see how that instruction could have been anything but prejudicial when the trial court said to the jury, Dr. Durrani isn't here, and you may conclude from the fact that he's not here that he would have testified, I committed malpractice on this patient. Your Honor, I see your skepticism. So the instruction says that a party, by failing to appear and present evidence, the jury may draw the inference that evidence would have been unfavorable to him.
Okay.
I don't know what that could mean other than the evidence would have shown or would have tended to establish that Dr. Durrani committed medical malpractice. That is what.
So how would you have changed that instruction if you had your way? How would you have changed that instruction to make it proper
It would not have been given, Your Honor.
at all?
It would not have been given at all.
So there would have been no instruction whatsoever about an absent party?
Your Honor, it's a civil case. He has no obligation to attend his trial. We have been having this fight for several years. It is true that plaintiff's counsel would have been free to comment on the fact that Dr. Durrani isn't here. We live with I live with the fact that my client is not here to testify. But you cannot simultaneously say the party has no obligation to attend trial and to issue an instruction that in some way punishes him for his absence. Those two statements simply can't be true. So our position is you can't fix the instruction, and the trial court, in fact, tried. This is at least the second or third iteration of a Durrani is not here instruction that's been given in these cases, and they've always been improper. I think there's no fixing it. You just do not give the instruction.
Okay, thank you.
Your Honor, I think the third problem, and it's one that the court is beginning to get familiar with, is the fact that plaintiff's primary expert, Dr. Wilkie, was not competent to testify at trial. He wasn't competent to testify at trial. He wasn't competent to testify 6 months after trial. He wasn't competent to testify when the court got around to deciding the post-trial motions in this case. I think the prejudice from having an unqualified expert testify is pretty straightforward. But it's absolutely clear that when Dr. Wilkie testified, when his testimony was objected to, and when post-trial motions were filed.
Was he competent to testify when the claim accrued?
Likely, yes, Your Honor. We think, as I think we have discussed before, there is some evidence that Dr. Wilkie may have been testifying when would have amounted to a contingency fee arrangement. There are different fights that we might have had about him, but he was perhaps competent to testify at the time the claim accrued, at least assuming he was not testifying as the hired gun that Rule 601 is designed to prevent. I acknowledge the rule, the Evidence Rule 601 has been amended in the interim, though it's like Section 13 or Section 1100 or Section 1300 reference to the rule says you apply it to ongoing proceedings unless it would work an injustice. In that case, you apply the formal rule, and we think it would work an injustice here. One of the reasons it would work an injustice is that if you apply the amended rule, what you're telling the trial court and what you're telling plaintiffs is you can effectively wait out an error. This is a case that was trial.
But is that what happened here? You had COVID, you had, I believe, some tactical continuances possibly.
Not on the part of the defense.
Okay, so
If there had been a tactical continuance on the part of the defendant, we might be in the Kelmer exception, we'd be having a different conversation. At no point has anyone alleged that Dr. Durrani is the cause of the delay that led to Dr. Wilkie being incompetent to testify. And the issue here, it isn't really COVID. As far as the application of the amended 601, Rule 601 goes, the delay is that the trial court didn't issue a decision on the post-trial motions. We are here because there was a lot of post-trial delay, largely occasioned by the trial court. And the trial court should have granted the motion to disqualify Dr. Wilkie before trial. There's a motion in limine seeking to exclude Dr. Wilkie because he is not competent to testify under Rule 601, and the trial court denies that motion. But that's not a delay problem. That is just the day that the decision was issued, the trial court was flat wrong about
Just
the
letting you know,
application of Rule
counsel, you have
601.
about 3 minutes left.
That was, just so I understand the timing here, the trial court denied that motion based on Selmer or Kelmer, however it's pronounced. And then the decision, and I'm forgetting the name, from the Supreme Court came out later that, that said that that rule is only for those particular facts in Selmer or Kelmer, right?
I would be lying to you, Your Honor, if I said I remembered exactly the order of Abdullah and the
that's it,
trial
yes.
in this case.
Okay. Okay, I wasn't sure of the timing, so, okay.
But at the time the motion was filed, at the time trial occurred, the trial court was just wrong about the law. There's sort of no two ways about it. The trial court simply got the law wrong. And what plaintiffs have effectively been able to do is wait until the law has sort of changed behind them to get a different result. And that we think is an injustice. You're effectively telling the trial court, as long as you sit on these cases long enough, you tell plaintiffs, if you sit on these cases long enough, eventually the law may come around to bail you out. And I think it works an injustice.
But isn't
for
that
defendants.
argument premised that there was foresight that the law would have changed?
Your Honor, I can't imagine that plaintiffs or the trial court had that kind of foresight in this
I mean,
case.
but that, it seems to me that that's
what.
what your last argument was premised on.
Your Honor, it's a form of really blind luck here. It's not even that you had the foresight to see the law would
Okay,
change.
so it's a matter of blind luck, so I don't know if there's any, like, messaging then that really can apply to this case.
Again, Your Honor, what you're allowing is delay doing the work of following the law. You have a decision that is inconsistent with the law, that is rescued only because no one reached a decision.
But then that would
at the proper
apply to
time.
every case, counsel, then
Most,
that would be, every case would be consumed in that.
Your Honor, candidly, most cases in this court do not involve the kind of lag time between, trial and decision and appeal that you are seeing, not just in this case, but in most of the cases involving Dr. Durrani where you're going to see me, you are seeing 1, 2, 3, sometimes even 4-year gaps between a jury verdict and a final appealable order. You're even seeing 2-year gaps between, a post-trial motion, a decision on a post-trial motion, and a final appealable order coming out of even that decision.
Good. Let me check with the panel to see if there's more questions.
I just want to
Yes,
clarify
we're out of
something.
time. But
You-
ask any question you like, as many of you like.
Stay here as
Doesn't
long as
apply to
you want,
you.
Your
I
Honor.
think it only be one. Now, you indicated that the trial court's decision denying the motion with respect to the expert was in error, correct?
Correct, Your Honor.
And you, I believe, just said that that erroneous decision was rescued, was the word I think you used, by the change in the rule. Is that
Assuming you affirm, that will be the result.
right? But the rule rescued that erroneous decision. The rule change rescued the erroneous decision.
Yes, the rule as currently, the rule is currently written, if applied to Dr. Wilkie, he would be permitted to testify unless that rule change would work an injustice to the defendant.
Got it. Thank you.
Thank you.
Thank you, Your Honors.
Good Morning, Your Honors.
Good morning.
Ben Moran on behalf of Applee Chris Clark. First of all, I'd like to say, generally speaking, we would stand on our brief, but more specifically, addressing some of the issues in terms of the comparative negligence. The negligence that's been alleged in this case is recommending an unnecessary surgery. I've tried 121 cases, so I'm very familiar with the fact patterns that we've dealt with in the majority of these cases. And that is based on misrepresentations of prior treatment. And I say that because in all of these cases, the evidence is that Dr. Durrani never gets any of the prior medical records. In this case, he made a recommendation for surgery on the first visit based on a 1-year-old MRI. So the claim for unnecessary surgery is based on the representation of prior treatment, on the imaging studies. And how do you compare the negligence of a patient relying on what the doctor is telling them? It just isn't an instruction that you can give. So for that issue, there's no basis for giving a comparative negligence instruction.
Well, the argument this morning, I think, whittled down to this on that, that there was a pain and suffering award. There was a motion for judgment notwithstanding the verdict, and that the error of the comparative negligence somehow affected that pain and suffering, and then thus the judgment notwithstanding the verdict should have been granted. It wasn't articulated that way, but as I pieced it together, that's what I pieced together.
In this case, from what the evidence was,
I'm going to ask the bark of the court to just, excuse me, if you can just okay?
the evidence was that Mr. Clark went in to see Dr. Durrani. Dr. Durrani told him, you need to have this surgery at the first visit. He had one injection that was tried. Dr. Durrani had recommended doing 2 because the evidence will show that, or did show, that you do conservative treatment before you recommend surgery. And then after he has this first surgery, there are issues that develop. He has a cerebrospinal fluid leak. He ends up having to have an emergent second surgery to repair the damage from the first unnecessary surgery. So all of that pain and suffering resulted out of an initial unnecessary surgery leading to a second unnecessary surgery. It was necessary from the standpoint because it had to fix damage that occurred in the first surgery, but it would have never occurred but for the fact that he had the first unnecessary surgery.
And I think what opposing counsel is arguing is that the jury was not able to effectively consider the Mr. Clark's disengagement with physical therapy because of the absence of the comparative negligence instruction. How would you address that?
They heard the testimony from all the experts. I know after doing 121 trials that when the issue of physical therapy has come up, that not all orthopedic surgeons or neurosurgeons even order physical therapy after a surgery.
Was there any testimony in this case from anybody saying
I
what you
cannot
just said?
say specifically because I haven't seen.
Because it doesn't matter what happened in other cases. We're only
Right,
looking
but
at
I
this
know,
case.
I'm confident, having done the number of trials that I've done, that issue when it's brought up by the defense that, well, he didn't do physical therapy, so that's why he's got all his problems, that my or my co-counsel's questioning of the experts is, do you even have to? So I'm confident that if that issue was raised in this trial, it would have been addressed by our experts. That's all I can say. I can't say 100% though.
Okay, thank you.
So what you're saying is that you believe that the record shows that the physical therapy was not required, and thus there was no need to have the comparative negligence instruction. Is
Yes.
that what I'm understanding?
Yes, and not
Okay.
only that, there would have never been a need for physical therapy had there not been an unnecessary surgery.
What about this argument that he went back to the job that caused him the back problems in the first place?
Well, in order to go back to the job, he would have had to get a release from Dr. Durrani to do that. There was no evidence that despite Dr. Durrani's requirement that he not go back to work, he did anyway. There's no evidence in this case about that. So that if you're told before you ever have a surgery that you're going to be fixed and be able to do what you were doing before you ever had these problems, going back to work would have been one of those things. So there's nothing wrong for him to go back to work after a surgery that supposedly was going to fix him. You know, in terms of Dr. Wilkie, the issue has been addressed before, and I know for a fact that in terms of Dr. Wilkie's qualifications, he has reviewed over 500 of the Durrani cases. He trained at the same spine institute that Dr. Durrani trained at, and these are all things that are in evidence. Right before COVID, Dr. Wilkie was working full-time as an orthopedic spine surgeon. COVID not only shut down hospitals, it shut down the trials for a year. We had no trials for 1 year.
Well, let me just push back a little bit.
Okay.
So the Supreme Court has said, when it comes to Kelmer or Selmer, however you pronounce it, that that case must be kept to its facts, which in that case it was the defense somehow delayed it, which made the expert unqualified to testify. So if we follow the Supreme Court's mandates, which we must, can we find that, make a different exception under COVID?
And I have to admit, I did not read Kelmer in preparation for today because I wasn't even understanding that I was going to argue this. But I also think that when you're looking at something as serious as what happened with COVID, where it not only shut down the court system for a year, stopped every single trial for a year, it stopped many of the elective surgeries, it stopped people from practicing, and that's what happened to Dr. Wilkie. And then after COVID and when hospitals started opening up, there was even the possibility of him going back to the same hospital. He was the highest paid doctor on staff there, and it just didn't work out. He continued to do work, and then he subsequently was teaching medical school. He was working at a clinic, and he has always been qualified to do orthopedic spine surgery. He just wasn't doing it.
Okay, so, and I understand that you aren't the one arguing today, and you may not be prepared to answer this. But in Kelmer, the rule was if the other party is the reason for the delay, making the person ineligible, then the person can be qualified anyway. And then Johnson came out a full year after the pandemic started. And it's holding Kelmer to its facts. So how would we be able to make a COVID exception?
I can't answer that fully, but what I would say, and I'm trying to remember my understanding of the Johnson v. Abdullah case, because it's been a while since I've looked at that. Those are two, the Kelmer or Selmer and that case were different from a factual standpoint. If I'm remembering Johnson correctly, that was an expert who was an administrator at a hospital, or he had a lot of administrative duties, yet he testified as an expert, and they said he wasn't qualified because the majority of his duties were administrative and not in practicing the area of expertise in which he was testifying. And again, I'm not prepared to fully address how you qualify that based on what Selmer says and Abdullah. Clearly, the COVID epidemic was not something that was expected, and it affected people across the board in all different professions. And there was certainly no delay on the part of the plaintiff, either in having the trial so that Dr. Wilkie could testify, or in getting the judgment entry finalized afterwards. I felt like there was something being argued that, there was this delay that happened in order to get us to the point where the law currently would allow Dr. Wilkie to testify. And that certainly wasn't anything planned out by the plaintiff.
Counsel, you have about 3 minutes
Okay.
left. Okay.
And if, certainly if this case was reversed and remanded, Dr. Wilkie would be fully qualified to testify under the current status of the law. Unless you all have any other questions, I don't have anything else to say.
Do you want to address any of the other issues?
In terms of the negative inference, it wasn't represented that you must find that Dr. Durrani would not have anything to say in his defense. It said you may infer, based on his absence, that he wouldn't have anything. And then there's no prejudice because within those instructions in a different area, they go into great detail telling and explaining to the jury what an inference is. So there's no prejudice. And it certainly wasn't represented to the jurors that you must find that this would be a negative thing, that he couldn't defend himself, and that's why he's not here.
Did the instructions also include an instruction that the jury could either make an inference or not make an inference as they chose, something to that effect?
Well, I think when you say may,
No, I mean, as separate, was there a separate, besides the may, was there a separate thing about, like, that the jury was free to make or not make or something like that? Was there another piece to the instruction, or am I confusing with another case? I thought there was a third piece to the
well,
instruction.
and the other thing that happens is the first instruction is, do you find that he was negligent? Yes or no? If you find that he is negligent, explain why he was negligent. And I'm very confident that it didn't say anywhere in that response from the jury. They write out a paragraph that he's negligent because he didn't show up and wouldn't have anything to say to defend himself. Other than that, there's not that I can recall, is there anything specific?
I don't know, are there any other questions? Do you want to make a
I
wrap up there? Because you have a few seconds.
I guess the one other thing I would say in terms of the whole physical therapy thing,
You have to make it really quick.
the one thing I would say is that I know that there's testimony that, from both sides, that in terms of someone coming in with a back problem to a spine surgeon, only about 10% of the patients are actually operated on, and they try to do other kinds of treatment.
Thank you.
Thank you.
Your Honors, I will do my level best to be brief here. My colleague began by saying that he will stand on his brief, but if you read the brief, very little of what you heard from my colleague's argument appears in that brief, and very little of it can be found in the record. For example, my colleague said that Dr. Durrani recommended surgery on the very first visit. That's not true. It was on the second. You can find that on page 767 to 768 of the transcripted trial. My opposing counsel stated that very rarely in his history of cases that as the physical therapy issue comes up, most spine surgeons don't even recommend it. That's not supported by the record. So Dr. Wilkie does testify that he may or may not recommend physical therapy to his patients. Defense expert Dr. Kalustian does recommend physical therapy to nearly all of his patients. And Mr. Clark's own treating physician 10 months after surgery recommended that he undergo physical therapy, an instruction that Mr. Clark continued to ignore. The bit about Mr. Clark only returned to work because he got a release from Dr. Durrani is not only not in the brief and not in the record, it's actually inconsistent with the trial court's reasoning.
So what I understood him to argue, that Dr. Durrani had purported that he would be able to return to work post-surgery, and I understood that as part of the lure to having the surgery, not as part of more of a medical instruction or prescription post-surgery.
No, Your Honor, opposing counsel said Mr. Clark wouldn't have returned to work had he not obtained a release from Dr. Durrani to do so, and that there's no evidence that Dr. Durrani did not give him the release. And that statement is inconsistent. It's both not supported by the record, and it's inconsistent with the trial court's reasoning on denying the comparative negligence instruction. The trial court said Dr. Durrani recommended but did not require physical therapy. But apparently, somewhere in the record, Dr. Durrani did require or order Mr. Clark to stay away from work and then permitted him to return to work. I don't know where these things are found. I don't know how you reconcile those two lines of thought, except either Mr. Clark was supposed to follow all of the instructions he was given or he wasn't. And if he was supposed to follow all of the instructions he was given, he should have followed the instruction to undergo physical therapy as well. Judge Bach, I do have an answer for you on the timeline on Johnson v. Abdullah. So Johnson actually starts in this court in 2019. So this court's decision in Johnson, which sort of similarly held, you follow the language of Rule 601, was decided in 2019, 2 years before this case went to trial. The JNOV motion in this case is filed in 2022, which comes after Johnson's decided. So Kelmer has been limited to its facts when the trial court says, I'm going to ignore the fact that Dr. Wilkie was not qualified to testify. Again, the day the decision is made, the trial court is just wrong about the law. And the Ohio Supreme Court had COVID in front of it and said Kelmer is limited to its facts when it decided Johnson and when the trial court in this case ignored it.
So let's say that we agree with you that at the time that the trial court made its order about Dr. Wilkie, let's say that we agree with you that that the trial court was wrong when it made its order. 1102, why? So when it says pending cases, does that include appeals? And when I ask you that, I'm asking, do you have any case law that says that it doesn't?
You're right, it does include pending appeals.
Okay.
Yeah, we have granted that if you apply the revised Rule 601, Dr. Wilkie is qualified to testify at least under the 601 rubric.
Okay.
It's that 1102Y says unless applying the new rule would work an injustice, in which case you apply the former version of the rule, and we think it does here, because what you get is a trial court ignoring the law. The decision was as flatly wrong as it could be, and it sat that way for almost 2 years before we got a chance to bring it on appeal and get it reversed, and then sort of in the interim, the General Assembly recommended a change to Rule 601. But the fact that, I have come to this court many times and I have I've eaten my fair share of crow and grief about delays in this case, very few of which have anything to do with my client. And now we come to a delay occasioned entirely by the trial court and plaintiffs that is to inure to their benefit. Again, seems,
You're out of
Interesting.
time. If you want to wrap up, I'll give you a few seconds to wrap up.
the last
To
thing,
wrap up.
yes, Your Honor.
To
The,
wrap up.
Your Honor, gives rise to an inference. That's the challenge instruction below, not may draw,
Okay,
gives
thank you
rise
for
to.
your argument this
Your
morning.
Honor.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. We wish you both a wonderful afternoon.
Thank you, Your Honor.
.435 Investments versus CBG Investments.
Good morning, Your
Morning.
Honors.
How are you doing?
Just fine, Your Honor. Thank you very
Thank
much.
you for waiting this morning.
Not an issue at all.
Okay.
I'd like to reserve 5 minutes for rebuttal.
All right.
I know that this court is aware of the facts of this matter, and to be blunt, this appeal doesn't really relate to the factual findings made below. Instead, this appeal involves the proceedings in the lower court and the improper issuance of a charging order by Magistrate Baradon as a magistrate's order, and the requirements in the magistrate's order that are not permitted by the Ohio charging order statute, requirements as to issues that were admitted and found and acknowledged by the parties, or which are entirely unnecessary.
And naturally, you want to get to the merits of this. I understand
Correct.
that, right? But we also, and I appreciate both of you, submitting your responses with regard to the mootness, since the debt has been discharged at this point.
And to that point, again, there are 5 requirements of the charging order, the magistrate's charging order. One is the issuance of the charging lien, which was also avoided by the bankruptcy court, so the charging lien does not exist. But there's also.
And you both agree to that fact?
Correct.
Yeah.
And counsel in their brief indicated that the requirement that the trial court exercise oversight over distributions by the charged parties, it was also moot. I think it's ambiguous on this issue. But there are also the requirements that I provide an accounting of the funds held on my trust account for the charged parties, which is unaffected by the bankruptcy court, and that Mr. Goldschmidt provide a proof.
Let's talk about that. Unaffected, you're talking about unaffected because, are you talking about whether it was complied at the time that it should have been complied with, or whether you still have an ongoing obligation to provide that accounting?
Well, we did not provide that accounting, and Mr.
Right.
Goldschmidt
So
did.
what I'm asking you
Yes.
is whether it's unaffected on your failure to comply at the time that it should have been complied with, or that it is still an order that you have to comply with from here on forward as well.
It's still an order that is unaffected by the bankruptcy court. So it's our position that that order must be complied with, or as
So
counsel.
you're saying that right now, you still have an obligation to provide accounting. As we have this discussion today, on Monday, June 16th, not back when it was ordered. I want to make sure we're at apples and apples, and in fact, green apples and green apples.
That is an order of the court that we provide the accounting. The accounting has not been provided. That portion of the charging order was unaffected by the bankruptcy court proceeding.
Again, I want you to answer my question straight on.
There's a motion for contempt against myself and.
Correct,
and my
and so
client.
there's two, that's why I'm breaking this down into
Right.
two things. I'm
Right.
breaking it down into non-compliance, and there's a motion for contempt on that non-compliance at the time when the order was in effect.
Correct.
Okay? Now we have a discharge. Are you saying that you're still under an obligation to provide an accounting on June 16th, 2025, and onward, that the court can still effectuate that order for you to provide accounting? As opposed to hold you in contempt for the prior failure to not provide the accounting when the order was in effect.
I misunderstood your question, Your
Okay,
Honor. So let me-
that's why I want to make sure we're not only in apples and apples,
I
but green
understand
apples
that.
and green apples.
So if I understand your question correctly, and if I don't, I apologize. If they filed a new motion and included a request that we provide an accounting, I think a new request would be barred because the charging order itself has been avoided by the bankruptcy court.
Okay,
But I think that, to answer the way I interpreted the request on on mootness, is that there is a court order, and a defense to a court order is that court order is issued without jurisdiction or is subsequently reversed by a court of appeals. And so that's why I've interpreted the mootness issue is that those two issues, my compliance and my client's compliance, are still before the court. If the trial court had not included those requirements, the magistrate Baradon had issued a charging order and just said, this is a charging order, there's a lien on his membership interest, and if any distributions are made on account of his membership interest must go to the plaintiff, we would not be here. I would agree that those issues would be moot with the possible exception of the general public interest of a magistrate
and I
acting.
appreciate that because I was not clear in reading the responses on what the response was saying.
Okay.
Because it felt as if it was saying that the portions of the order that are complained of, okay,
In this appeal.
in this appeal, the
Correct.
portions of the order that are complained of in this appeal, that they somehow survived the discharge, and I'm not talking about the contempt for failure to comply when the order was effective. I'm talking about June 16, 2025, that somehow that survived until today and beyond. That's what I'm trying to get understanding, whether you believe that these portions that are complained of in the appeal have survived the discharge, that they're still effective today, that they still could be effectuated in some way, shape, or form, for example, orders of contempt, for example, orders against the LLCs.
Correct. Those portions of the order that have not been complied with are still effective today, and it's still a controversy today.
But are they in controversy so that you can be ordered today to provide the accounting, that you could be held in contempt today for not filing the accounting
One of the issues,
since the discharge until whatever?
one of the,
See, you're muddling up the answer again.
I understand that, Your Honor.
And I think that this is really goes to mootness, very clearly goes to mootness.
I go to that a court order has been issued that I view as invalid for lack of jurisdiction, that ordered me to do certain things and my client to do certain things, and we did not do those things. And so, as I sit here today, I don't know if the trial court is going to say, okay, there's been a discharge, but we've got these two provisions, there's a pending motion for contempt, so come on down, let's all argue about the
But
motion
those are
for
separate
contempt.
things. Again, you're muddling it up because, let me ask it a different way.
Okay.
So one of the issues one of the portions that you have an issue with has to do with the order to the charging parties. Shall not directly or indirectly pay any obligation owed by Goldschmidt, right?
Correct.
Okay, so, now that this debt has been discharged, if Goldschmidt accrues a new debt, will this portion of the order survive and can be applied against the LLC independent of this cause of action, in a new cause of action?
I would say it's unclear, but to answer your question, I would say no, because the charging order, which that is based upon, has been avoided by the bankruptcy court.
Okay, so that answers my very first question, that this is not surviving past the discharge of the charging order as far as can it be effectuated today, June, okay?
Correct.
Right, which is separate and apart to the pending contempt action, which
Correct.
we recognize that there's a pending contempt action. There's
Correct.
actually two, I believe. But
One motion, two reliefs.
Yeah, yeah. So, but with regard to the one that's really being discussed is the contempt for for like the failure of complying with the accounting.
Correct.
Okay, at the time that the order. So let's now talk about that part of mootness, if we may, okay? Are you saying that, because there's civil contempt and there's criminal contempt?
Correct.
Right?
Yes.
There's case law that says that a civil contempt will not survive past, in other words, that's, if there's a civil contempt with regard to failure to comply with an order while that order was effective, and that order is then subsequently discharged, that civil contempt does not survive. Are you aware of that?
I'm not aware of that case law, Your Honor.
Okay. Is that a game changer to you in how you feel about this?
So if there's case law that says I'd really have to think through that, Your Honor, because there's a court order that's independent of the charging lien and independent of a monetary judgment that says I have to do certain things. If there's case law that says if the bankruptcy court discharges the debt and avoids the lien, then those ancillary requirements are also discharged. Yes, I would agree that it's then moot, but I'm unaware of that.
What if I were to say that there's case law that says that if there's an order that is later found to be invalid, okay, but there was failure to comply before that determination of invalidity, that it cannot be that any civil contempt at the time of validity does not survive?
Well, and there is case law. I'm aware of that case law, that if a court order is issued without jurisdiction or is later reversed, no contempt can arise from the noncompliance.
So
But
then why do we have to address it? Why do we have to address
because we need,
your assignments of error?
we need a determination by this court, either that Magistrate Baradon lacks jurisdiction to issue the order, and therefore the contempt goes away.
And I think
or-
that's the key, is we need, why do we need? That's what I'm trying
Because
to understand.
it's just what you indicated, that the case law is that if a order is issued without jurisdiction or later reversed, the contempt, there's no contempt. But in this case, there's no order from this court that Magistrate Baradon had or did not have jurisdiction, and there's no order from this court that the requirements that he imposed exceeded the permitted remedies under the statute.
And that's what, you have to get that invalidity order from this court to get out from under the contempt proceeding. That's the whole objective
Correct.
here, right?
So if this court reverses and vacates the charging order, then the motion for contempt before the trial court becomes moot, because the order that it's predicated upon has been reversed by this court.
But my question is, why was that trial court's order ignored? I mean, at that point, when the trial court had given that instruction, it was an order from the court that was not complied with.
It wasn't an
My
order from the-
question is, how does that happen?
We made the choice. First, we did try a writ of prohibition action that this court dismissed, arguing that they were without jurisdiction. The Magistrate Baradon was without jurisdiction. And in that decision, dismissing the case, says you've got a right of appeal. And I understand there's a risk that this court could find that Magistrate Baradon had jurisdiction, or that the requirements of the charging order to provide information was consistent, permitted by the statute. And if I complied, then my appeal would then be moot, because I voluntarily complied with an order of the court that I'm then appealing, and there's a ton of case law that says if you voluntarily comply with an order, you've mooted your arguments on appeal. And I believe that these issues with the magistrate's authority and these requirements, I mean, the magistrate's authority issue is a significant issue for attorneys, myself, that appear and practice in Hamilton County. What authority does Magistrate Baradon have to issue substantive orders? And again, he clearly
But
said,
why wouldn't you appeal instead of ignoring the order?
I did appeal. That's what we're here for today.
No, but, so I'm confused as to the contempt proceeding.
The contempt proceeding was put on hold when bankruptcy was filed. It had been fully briefed, but just no hearing had been scheduled on it. And then when the discharge order was entered, the trial court could have said, okay, we're now going to proceed on this contempt proceeding.
The motion for contempt followed your appeal. Is that, am I understanding your timing correctly?
No, I think that the motion for contempt, well, it did follow the initial notice of appeal. We had a magistrate's order. We requested that both the trial court and the magistrate stay or grant relief from it, but since they did not act within 30 days and aware of the risk of, you can appeal too early, but if you appeal too late, your appeal is done with. We appealed at that point in time. And then they filed the motion for contempt about 2 weeks after we filed the first notice of appeal. Then this court remanded, then Judge Triggs denied the motion for relief without authority to do so, without jurisdiction because of our pending appeal. This court remanded to Judge Triggs consideration of our motion for relief. And Judge Triggs then in September of 24 entered a second order denying it. So the motion for contempt was filed and brief. We did not seek a stay. Well, we did, I take it back. We did seek a stay of that order, but neither Judge Triggs nor Magistrate Baradon acted upon the motion for stay.
And I guess maybe I misheard you, but it seemed like you were saying that you took a calculated risk to ignore the magistrate's order. Did I mishear you?
I spoke too hastily. We decided that since we'd filed a writ of prohibition, we had filed the motions for stay, we'd filed the motions for relief, that if we complied with the order, then those issues all became moot. And we were being asked to provide information regarding non-judgment debtors, non-parties to the litigation, and Mr. Goldschmidt was being ordered to produce documentation on facts that the trial court, Magistrate Baradon, had already found. Under the statute, doesn't matter to the extent of your membership interest. Just are you a member in the LLC? And he found, and we admitted, that Mr. Goldschmidt was a member of these three LLCs. And he had to do so within 5 days. And this is not in the record, but the building that all those records were in had been demolished at that point in time. I take it back. Maybe there is a comment in the transcript.
I think that is in the record somewhere.
I think there is a comment. I say that. And so he was being asked to perform an unnecessary and impossible act. And so we disagreed with legally the jurisdiction of Magistrate Baradon to issue the order, and we took steps to address that. And then we disagreed with the ability of Mr. Goldschmidt, even the requirement that he do that, because it was completely unnecessary. It seems like they were setting up the contempt because they submitted these requests not in their motion. Their motion, their emergency motion, was simply for a charging order. These requirements were not addressed at the hearing before Magistrate Baradon. When counsel circulated the proposed charging order, that's when these issues arose, and that's when we objected to them and were ignored by Magistrate Baradon and ignored by the trial court.
I'm going to do a pause here. I just want to, and you have more questions?
I do have a question I want to ask, but if you want to
No,
continue
no.
on with the mootness, I can wait.
No. Is it on the merits?
Yes.
Okay, because we're out of time, so I'm just going to make a proposal here.
Okay.
Okay? So first of all, do you want to take any of your 5 minutes and use that towards addressing on the merits?
Do I have an alternative?
I might, well, first, do you want to take some of that?
I would like to address some of the arguments I've written in the brief.
Okay, so how about, are you willing to take 2 of those 5 minutes?
Yes, that's fine.
Okay, and I'll give you then 2 more,
So I've
and
got-
I will also give opposing
okay.
counsel more
Well, I
time.
got 4 minutes and then 3 minutes of rebuttal.
Okay.
All right, thank you.
Is that fine?
Yeah,
All right.
that works for me. So quickly, I just want to say that I believe that the Ohio Supreme Court has already ruled on jurisdiction, that the magistrate might have lacked authority, but did not lack jurisdiction. Would you agree with me that the Ohio Supreme Court has already ruled on the jurisdiction issue?
In denying the appeal from this court?
Yes.
I don't know because it was a one-line
Oh, it was a little bit more than
on
that.
that. But I go back to this court saying, and it's whether it's the standard for writ of prohibition is patently unambiguously lacks jurisdiction.
Right.
And so the court said that doesn't unambiguously, but I still believe that the jurisdictional issue.
I think
I
that, I'm going to
apologize.
stop you. I think the authority issue is a lot more interesting, and I also believe, and correct me if I have missed something, but I believe that whether a magistrate has the authority to issue a charging order as an order rather than a decision is a matter of first impression in the state.
It's never been directly addressed. We cited a number of cases that it's never
I
occurred
understand that.
before. Yes,
I understand
but
that.
it is a case of
It
first.
might have occurred, it just wouldn't have gone up on appeal in a published case.
In none of the published cases, is there a case where a magistrate issued a charging order and the validity, authority of the magistrate to do that was an issue on appeal.
Okay, so my next question, so the rule says that the magistrate can enter orders without judicial approval if necessary to regulate the proceedings and if not dispositive of a claim or defense of a party. The more interesting part to me is if necessary to regulate the proceedings portion. This is a post-judgment issue. At this point, is it collection of a judgment debt? Is this a procedural issue, or is this a substantive issue?
I argue that this is a substantive issue because they granted a claim.
No, the claims are down below.
No, I see, and this is where I respectfully disagree. Dispositive, to regulate the proceedings, we need to move a hearing date. We need to enforce a subpoena. We need to swear in a witness. Those are procedural matters that regulate the proceedings. This is a claim to an asset. It is a motion that I'm going to impose upon a non-party to the action obligations. And so I don't believe that the rule distinguishes between post-monetary judgment and pre-monetary judgment. It says if not dispositive of a claim or defense of a party.
So something you said just caused a question that I hadn't really thought of. So you're saying that it's forcing another party to do something, which in a way it definitely is. I guess my question here is, so a charging order, it doesn't affect the LLC's income and flow because the only portion of their income and money that they have to turn over is that the judgment debtor would have been entitled to had it not been for this, correct?
On account of his membership interest.
Okay.
And that's also a key distinction.
Oh,
Because it's not just any distribution from the LLC. It's distributions otherwise be entitled in respect of the membership interest.
Correct.
So if the LLC is making an ownership distribution, then that distribution has to go to, after a charging order is issued, has to go to the judgment creditor.
correct.
And that's one of the issues I have with the requirement that the judge has judicial oversight over what distributions can and cannot be permitted. But I do believe that the Civil Rule 53 does not contain a distinction between pre-judgment motions and post-judgment motions. It's all to regulate the proceedings. And arguably, Magistrate Baradon granting a motion to dismiss as a final order regulates the proceedings. It ends it. Magistrate Baradon granting a motion for summary judgment regulates the proceeding. It ends it. When you take a look at the rules, the civil rule that talks about regulation of proceedings, in C3, there are 6 examples of when a magistrate can issue regulation proceedings, and none of those are charging orders. They're all issuing subpoenas, admissibility evidence, witnesses.
But
and
that's
oath
including but not limited to, correct?
It is, but the rule and I can't pronounce it, the rule says if we have a list, things outside the list should be interpreted consistent with the list. You just can't go off on a whole new tangent and issuing a charge order, which, and again, Magistrate Baradon admitted on the record that this charging order granted substantive relief.
Do we have to agree with him?
Well, it shows that his inclination was, he said 2 things that are important. One is, he wanted to do it as a magistrate's order, so it was effective immediately. Again, there's nothing in Civil Rule 53 that gives discretion to the magistrate to choose a magistrate's order so that it can be effective immediately. And again, also that he knew he was granting substantive relief. And there is case law that clearly says magistrates do not issue orders that grant substantive relief.
All right,
We cited
thank you.
those in our brief.
All right, thank you. All righty, so why don't we start off with mootness and see what happens?
Absolutely, Your Honor. If I can maybe try to tackle the opening question you had for my colleague on the other
Okay.
side. The non-monetary portions of the magistrate's charging order are in effect. Like, if this goes back down today, they still need to be complied with. The bankruptcy, our position would be the bankruptcy can
So
discharge
I
the
want to make
under-
sure I understood your answer fully, okay? So you're saying that there could be a new motion of contempt that you can file, for example?
We could, Your Honor. I think we would rest on what we have. We could. I think there are some practical challenges. But if you're just, again, starting with that question, is the order in effect today?
Yeah,
Yes. The bankruptcy, our position would be the bankruptcy can discharge the underlying debt. That doesn't mean that it, sort of by automatic operation, discharges any order that may be tangentially related to it. Now, as a practical matter, if we go back down, do I expect that the trial court would vacate the remainder of the charging order because there's no longer an underlying debt? Yes, I strongly suspect that's what will happen. But that's a decision for the trial court, not the federal bankruptcy court to make.
okay. But there's also an order avoiding the charging order, is there not? From the
Well,
bankruptcy court?
it is avoiding the monetary requirements that, that the money be paid to 435 Elm rather than to Mr. Goldschmidt. I would contend that the bankruptcy court can't actually avoid the non-monetary elements of that order. The bankruptcy court does not have what would amount to like sort of roving jurisdiction to upend every proceeding that is currently ongoing. The bankruptcy court deals with the financial matters of the judgment debtor of the bankrupt, but it is not a as I said, sort of not a roving charge to dismiss everything.
But, it's interesting, I guess as a matter of practicality, you have it all encompassed in one order, right? And that one order is called charging order, right? So, if it's all one order and it's called a charging order and the bankruptcy court has spoken on the charging order, then how is it, explain to me how these components would survive
Your Honor,
when they're already they're encompassed in that order that has been spoken of?
Your Honor, I will grant to my friend on the other side, I think a fair argument. But the charging order itself, I apologize for not having it in front of me. But the charging order sort of sets out its requirements, if I'm not mistaken, sort of as an in addition to or to enforce compliance with this order. I think there is a fair argument, you might say, yeah, the bankruptcy court said the charging order has been avoided. I would tell you, I don't think the bankruptcy court actually has jurisdiction to void the non-monetary aspects of that order. I think the reporters are as empty as to the bankruptcy court's jurisdiction on that score as my colleague says they are with regard to the magistrate.
Because here's the thing, I think it's, I think what's happening is it's being intertwined with those portions that may or may not be valid to begin with, ab initio, right? Okay. When I look at this charging order, there's a paragraph, it's the second paragraph, that defines what this is all about. It defines the parties, it defines the debt, it defines what this is all about. Then it goes on and gives different orders, right? So I think it could be said that all of those different orders come back to what this is all about, which then comes back to the charging order. And that once the charging order is addressed specifically by the bankruptcy, you can't piecemeal out of any of it because you have a paragraph that defines,
With the charging.
yes, and who it applies to and what the circumstances are. Because otherwise, what I was asking counsel was, for example, this order as to the charged parties, the LLC, because then the argument would be that that would survive past this order, which I see you smiling because, yeah, that's kind of ridiculous, right? You know, that would survive past this order, that if there was a new debt by Goldschmidt, that somehow the charging parties would be refrained from transferring any cash and so on and so forth because of this statement in this charging order that's defined by this paragraph, that's defined by the charging order that's been spoken of. And it seems to me that the concern that both have, if we speak on mootness and say this is moot as to, you know, anything going on from here on forward, there's nothing to be talked about, which is separate to now what do we do with the past contempt, right? That it's over.
Your Honor, so bifurcate, look, I'm appellee. Bifurcated the way you described, I think, from my client's perspective, it is fine if the court says, this appeal is moot, go back and deal with contempt. What would not, I think, work is if the court, rather than simply saying this appeal is denied as moot, says this appeal is denied as moot because the charging order is ineffective, invalid, what have you. A mootness decision that actually prejudices my still pending contempt
But
motion would be a real
invalid
problem.
now is very different to at the time that there was a failure to comply.
So, Your Honor, I'm not sure you could say this appeal is moot because the charging order is invalid. I think that word does some work. If you dismiss the appeal as moot because the charging order was subsequently avoided,
Yeah, it was avoided and the debt was
that-
discharged.
that may be fine. Again, without prejudice to my ongoing contempt motion. But sort of the more that the court says beyond this appeal is dismissed as moot, I think the more we begin to create some concern for my client on the contempt motion. But again, I'm appellee. If you decide you don't want to deal with this case and want to send it back to the
It's not
magistrate.
about not dealing with the case, it's about what is required of us.
But at
Fair.
this point, your client doesn't care about the contempt, right? I mean, they've gotten all the money that they're going to get.
Our client very much cares about the contempt, Your Honor.
Why? I'm trying to understand that.
So
Because
This will-
your client was concerned that there were some shenanigans going on with the money being transferred out and avoiding paying your client what was owed. Is that right?
So my client brought the contempt motion because he was very upset about the non-compliance. It came on the tail end of now 6 or 7 years of trying to
Right.
chase down this debt. My client is very interested in having the contempt motion itself vindicated. Because again, sort of up to this point, no one has found that Mr. Goldschmidt was at no point obligated to comply with the accounting requirements with the charging order. And his non-compliance caused some very real pocketbook injuries for my client, including but not limited to the fact that he's paying me to stand here today. And these are things that we think can still and should still be vindicated in the contempt motion, unless, and this may sound like an echo to you, unless we're willing to say you can sort of ignore the law and ignore a court order until circumstances change and you get out of it.
But they didn't ignore it. I mean, they filed various motions afterwards and filed an appeal. At least according to counsel, they didn't simply ignore the order, because that was a
I-
concern of mine, too.
I will apologize for the colloquial use of ignore, but failed to comply. I will say intentionally failed to comply with the order, which is why it's brought as inadvertence might get you something different. But this was willful non-compliance with the court order, and again, we care about having that vindicated because otherwise the answer is you can willfully non-comply with the court order, drag my client into what turns into a wild goose chase to chase down money that until very recently was owed to him, and then say, I'm sorry, your expenditure is out of luck because we've figured out a different procedural maneuver, and that's what happened, a different procedural maneuver to get us out of the underlying debt. So The bankruptcy was a procedural maneuver to get out of the underlying debt, which is something that
But is
Mr.
it,
Goldschmidt has been trying
it
to do
seems
since
to me
2018.
that the law that governs whether the prior contempt is independently punishable stands on its own. You understand what I'm saying? And it's kind
Correct,
of,
Joe.
it seems to me independent on the mootness.
Again, Your Honor,
You see what I'm saying?
From my perspective
So
as
whether,
appellee-
whether it's moot today is one issue. Whether the prior contempt is independently punishable is the second issue.
again, from my perspective as appellee, if the court's conclusion is the appeal is moot without prejudice to the ongoing contempt motion, and the court does not find here that Mr. Goldschmidt never had to comply, I think that's an outcome that we can live with. What would be troubling is if this court issues an order that effectively says the charging order was invalid or that Mr. Goldschmidt and his counsel never had to comply with that order. That's the outcome I think my client would prefer to avoid here.
That goes more to the merits, though, correct?
It does go more to the merits.
Okay.
But even if it was invalid, there are circumstances that the prior contempt is independently punishable,
Again,
even
Your Honor,
if
if
it's
that,
subsequently found to be invalid.
I'm not fighting with you on that point. If that ends up being the court's conclusion, we can live with that.
I mean, have you looked at the case law on this matter?
I
And I don't need, I mean, look, I know you've got a lot, so I'm not trying to be scrutinizing, it's just like, maybe you haven't had the time to look at that, and that's where you're coming before us,
You're-
and that's fine.
Exactly right, Your Honor.
Okay,
The
and that's
the
fine.
mootness is just
Understood.
relatively new and for all.
Understood, understandable, okay? No worries. Is there anything further that you want to speak on the mootness before you turn to the merits of it?
Nothing from us, Your Honor.
Okay, so you have, just so you know, you have 3 minutes left on your, no, hold on. You have 3 minutes left on your original 15 minutes, okay? So I'm going to give you an additional 3 minutes on top of that. So I'm
Thank you,
giving
Your
you the
Honor.
2 I gave him plus 1,
Thank you, Your Honor.
okay? So you can go ahead and address the merits.
Before you start, I'm sorry. I'm going to ask you
I was
a
gonna
very
turn one of your questions
specific
first.
question, yeah. So I believe this is an issue of first impression, correct? Whether a magistrate can order a charging order as an order rather than a decision.
That is exactly where I was going. Yes, Your Honor. We have not found anything in the Ohio reports where this has come up.
Okay, so my next question is exactly what I asked opposing counsel. Since this is a post-judgment collection action at this,
Correct.
or at least when it was filed, how does that affect the magistrate's authority?
Your Honor, and I think the question you started to ask was exactly right. An order cannot dispose of a claim or a defense. That didn't happen here. There's no defense that's been affected by this charging order. There's no claim that's been affected by the charging order. It is simply a matter of collections. And that, to me, sounds, not only does it sound more procedural, but more importantly, going to the language of the rule, it is not dispositive of a claim or defense, and so the magistrate has jurisdiction, I think, under the plain text of the rule, to address the charging issue via an order.
Well, I think it had jurisdiction no matter what. What I'm talking about is authority. So under the rule, it requires both necessary to regulate the proceedings and not dispositive of a claim or defense. So what I've been zeroing in on and trying to figure this out is the necessary to regulate the proceedings.
Yes, sir. Maybe give me a sense of like where you're having some heartburn.
Okay, so where I am having some heartburn is I'm trying to determine whether, as this is a post-judgment issue, whether a collection method is regulating the proceedings, or is it affecting, or did this order affect a substantive claim? Or not even a claim, sorry, a substantive issue.
Right. So I think if you look at sort of the flow of litigation, it is, your complaint, your discovery, your summary judgment motions, your trial, judgment, collection. These are the steps of the action. So the procedural issues I would read as what are the things that move us along, that get us from one stage to another to ensure that a stage gets completed, minus those areas where moving us along effectively ends the case. So, as counsel said, deciding a motion for summary judgment or a motion to dismiss, like, does regulate the proceedings insofar as it might end them, but it affects the substantive claim or defense, and so it's out of magistrate order territory. I think part of what you're looking for in the procedural issue is these are clearly things that need to be addressed now, rather than sort of being put off for what amounts to a mini appeal before the trial judge. That's why things like enforcing subpoenas fit into that immediately effective order category. And I think you have the same thing here, which is there's no dispute about the underlying debt. All we're trying to figure out is how are you going to pay me the money that all of us agree you owe me now? That strikes me as, the sort of thing that you need immediate relief on, especially when there's no underlying, factual dispute to resolve, not even an underlying legal dispute to resolve. What all you need is a court to say, you must do this. Like, the law is X, the facts are X, and because of those things, you must do this. That strikes me as the type of procedural order that you would allow a magistrate to handle an order, where they're not having to do, I don't want to insult my magistrates by saying, like, not having to do a ton of independent thinking, but they're not having to sort of build the legal apparatus themselves the way that we expect and demand and require our trial judges to do. This is, what the rules are, execute. You know that you have to comply with the subpoena, so execute. All I need is a court to tell me, comply with the subpoena. You have to pay me the judgment. All I'm looking for is for the court to say, you have to pay me. In this case, you have to pay me for the second time.
And if that payment is made, if the judgment is satisfied, then the right to appeal is now taken away. Correct?
Yes, Your Honor. I think at least in the ordinary course, voluntary compliance does moot the judgment, which is why.
And doesn't that have the effect of resolving the underlying matter?
Often, yes.
And so does that affect whether or not this can be an order or decision?
I don't know that it does, because even when you're talking about something like issuing a magistrate's order requiring compliance with a subpoena, you would do exactly what I think you may attempt to do anyway, exactly what opposing counselors does, which you would, even a magistrate's order, you can take to the trial court.
Right, but the question about a subpoena is not going to necessarily resolve the matter, bring it to a close, but the instruction to pay a judgment would.
Well, in this case, Your Honor, it's the time to appeal. We are 6 years post-judgment. The time to appeal the underlying judgment has well run. We are past the point where the validity of the judgment might be affected by an appeal. There's no dispute. You have a judgment debt against you for $1.55 million. The time to appeal has expired and you chose not to. The only question is now, again, 5-6 years later, how are you going to pay that judgment? Whereas a subpoena might be sort of part of a live case, this is, as Judge Bach has pointed out a number of times, we're in post-judgment territory. We are just in collections now, where you don't have any legal issues that might affect the underlying validity of the magistrate's order. You might have a fight that affects the validity of a subpoena or the admissibility of testimony or documents secured pursuant to a subpoena, because you might have an appeal post-trial, post-judgment. You do not have that here. We have a judgment debt everyone agrees is valid and final. I mean, that's why you have a concession that 435 Elm is at least entitled to a charging order. We're really only fighting about a couple of the elements of the order, not the entitlement to a charging order in the first instance. If I may, Judge Bach, it's a matter of first impression, but it's also, even among matters of first impression, a a really kind of bizarre factual scenario. You don't typically need a charging order to secure payment of a judgment debt, 6 years
Is
post-judgment.
there anything in the record that establishes that this is a recurring or common issue in this county? So let's say that the magistrate did overstep its authority. Is there anything to support that it's a recurring or common issue in this county?
None that I've seen, Your Honor. Given the way this case unfolded, I certainly hope not. But no, I do not have anything in the record that would suggest this is, a recurring or potentially recurring problem.
Do you want to wrap up?
So, Your Honors, if you have no further questions, then I will sit down and simply ask you to affirm the magistrate's charging order and then let us go back and fight about compliance. Thank you,
All
Your
right,
Honors.
thank you.
I'm going to address some issues that you raised, Your Honor. There are a number of post-judgment
So I
matters.
just want to remind you, you have 3 minutes,
All right,
okay?
thank you. That are resolved by a trial court judge. Garnishment orders are signed by a trial court judge. Contempt citations for not appearing at a judgment debtor examinations are signed by a trial court judge. So this distinction between pre-judgment and post-judgment is irrelevant under the analysis of the rule. I agree with my counsel. If this court merely dismisses or denies the appeal as moot, what happens next? He intends to go back to the trial court to find a contempt citation. I will suggest to him, and I don't know if it helps or hurts my mootness argument, if he tries to seek contempt citations and a monetary fine for Mr. Goldschmidt, that would be a violation of his discharge order. So really, he's coming after me for not complying with an order to I release information regarding my clients who were not parties to the case, had not been served with any discovery requests, had not been served with any subpoenas. He's just mad that I did not tell him how much money I was.
Ultimately, isn't this ultimately governed by the pre-existing law on whether a prior contempt independently is actionable? Whether, and there's 2 pieces to that. Is it independently actionable civil? Is it independently actionable criminal?
You raised that issue earlier. You also put in the context when the bankruptcy court does something to affect the order. So, and I don't know right now because I've not researched that issue. I do know that if
And I'm going to rephrase that because I think I'm phrasing it not completely. Whether it's independently actionable regardless of whether that order was valid or invalid ab initio.
Well, no, we have cited case law that says if a court order is reversed on appeal or is issued without jurisdiction, no contempt can lie. We have cited that authority, and there is authority on
Okay.
that issue.
Then let me change it this way, because you're right. If it's independently actionable after the order is no longer valid,
And I'm going to get to that point.
not ab initio, but after it's no longer valid.
By the bankruptcy court order, is that what you're referring to? Mm-hmm. Okay, so the bankruptcy court order did not discharge or avoid the order. The bankruptcy court order avoided the judgment lien and, well, and I drafted this, so it does say, in
See?
the issuance of a charging order.
And that goes back to, it's a
hereby
charging
avoided.
order, there's a paragraph in here that defines what this is, who it is, to whom it's applicable, and then you have all these things that come after. So even if some of these things went beyond the authority, we're still talking about
But
the avoidance of the charging order.
it said the issuance of the charging order are hereby avoided pursuant to the code section as to personal property and membership interests in Elm Street Deli, Lunar Lounge, as described and identified in the motion to void that I filed. So it was not simply say the charging order itself is avoided. It specifically refers to the personal property liens and the charging order as to the membership
Right,
interests.
but this is what's interesting to me. All of those additional orders, whether they were with authority or without authority, whether they were even with parties that weren't parties to the case, the LLC, which, brings an interesting argument. All of those things are are still going back, are all, we're supposed to be, whether they properly or not, we're supposed to be rooted in this debt, in this outstanding debt, right?
Correct.
So you've got that, so the premise of everything, the catalyst of everything, the root of everything is no longer there. And then you have this avoidance. So if it survives, then I guess, again, this part of the order for charged parties that's somehow surviving, if you're gonna tell me that the accounting survives, then that means that this also survives. And I think that we've already established that that's a little bit ridiculous, that,
Well-
right? So just because that one is so clearly ridiculous, doesn't make the other one somehow survive.
No,
That
the-
now you still have to do accounting on an order that, on a debt that your client has been discharged of, that you could be asked to do accounting,
I'm
which
distinguishing.
is separate and apart to the non-compliance.
Let me state it this way. I'm distinguishing between my compliance and my client's compliance with an order issued by the court that I believe I can defend if it was issued without jurisdiction and beyond this, what's permitted by the statute. Independent of, because it is a court order. The case law that I've referred to says, it really doesn't matter how ridiculous or how unnecessary the order is, unless it's issued without jurisdiction or reversed by a trial court, you've got to comply with it. So if he told me to show up on a Tuesday, and I simply didn't show up on that Tuesday, regardless of the purpose of it, but I believe that me showing up on a Tuesday was not permitted by the statute, that's my defense to it. It's not my defense to, because I'm an attorney and I comply with court orders that are validly issued. And so, is my time up? I thought I saw you say my time was up. And I don't want to go.
Just finish that
Okay.
sentence.
Again, simply dismissing the appeal or denying the appeal as moot creates more issues than it solves. In actuality, it most likely brings back another appeal to this court, because if the court does find me in contempt because I did not provide the accounting, my client did not provide proof of his percentage ownership, and then I'm going to appeal that, because certainly I can appeal that. There's no question contempt citation is not moot. And we're back before the court arguing the same issues that we're here today. And he's indicated, both in his pleading on mootness and today, that he intends to go back to the trial court and have his motion for contempt heard.
Okay, well, thank you for your arguments this morning. Thank you both for your arguments this morning. We will issue a timely decision,
All right.
and we consider the matters submitted. And we wish you both a wonderful afternoon and a great week. Thank you. I'll give you a minute, Carol. All right, and that concludes the proceedings for this morning.